And it's this new rule by the Federal Trade Commission talking about non-compete agreements and whether they're enforceable or not.
Yeah, so Florida is generally a state where you see a lot less regulation, a lot less control over things, at least on the employer side.
As many times they go hand in hand, you see non-compete and non-solicit. Can you talk a little bit about that to, the kind of the differences and the nuances between a non-compete and a non-solicit? Because I think those get confused a lot.
Of course, and they do. So a non-compete is specifically looking at prohibiting somebody from working for a competitor at all. And so it generally prohibits an employee from engaging in employment. A non-solicitation, they're usually divided into separate clauses: non-solicitation of employees and non-solicitation of customers.
So welcome again, friends. Thanks a lot for joining us for another episode of the Do It For Yourself podcast. I'm Steve Taylor. I'm the founding advisor over here at Merited Wealth. And our podcast, if you haven't listened to this before, is we really try to bring topics, we try to bring guests, we try to bring conversations to the table that might be useful for those of you out there doing it for yourself, right? Whether you're self-employed, whether you're a unique part of a larger company, whatever it might be. And so if you find this conversation helpful, please let us know. If you have ideas for other conversations, let us know, and that'll be great. And so today, really, this conversation, we have different formats. We go back and forth. We do subject matter. We do kind of an interview format. This one is really just on a subject matter, on a topic that's been coming up a lot lately, that we've seen it in the news really this past year. And there's a lot of information going out there. I think a lot of misinformation going out there, really about what it means, how does it affect a lot of these certain agreements that are already in place. And it's this new rule by the Federal Trade Commission talking about non-compete agreements and whether they're enforceable or not. So before we start off here, let me introduce and have our esteemed guest, Andrew Adams, kind of introduce himself and tell us a little bit about his background.
Thank you, Stephen. Hello, all. So my background started years ago. I went to my undergrad for marine biology and took a little bit of a circuitous route from there. After my undergrad, I then went into the Navy and enlisted. And from there was a member of the Hampden County Sheriff's Department for a little while up in Massachusetts, where I started going to law school when I was working night shift. So I took a little bit of a different route into the legal field, but primarily have always focused, even when at the Sheriff's Department, on the labor and employment side of it, albeit for a different side after I graduated law school, mostly representing the employer side interests, as well as a little bit of plaintiff's work as well. But I'm the practice leader of labor and employment here at Darrow Everett, and that's my full concentration these days.
Awesome, Andrew. So let's start with, if you can, for listeners, anybody out there, if you can give us kind of a non-compete agreement 101, right? I think a lot of people, don't really understand how they apply, where they apply, and everything. So, even before it was this new, rule came out by the FTC. How do non-compete agreements kind of, where do they come up? What makes them reasonable and enforceable, and kind of just for the listeners out there who don't have that much experience in them?
No, of course. And so a general non-compete is basically what it does is it prevents someone from working for a competitor or a different company in the marketplace developing a similar product in certain circumstances after their employment ends. And so with non-compete agreements nationally, enforceability varies because most of what happens in the employment side of our practice, not the labor side, but the employment side generally, a lot of it's driven by state regulation and state laws. So what is an enforceable non-compete agreement may not be an enforceable non-compete agreement in a different state. For example, Washington state requires a certain monetary threshold for an individual or an employee to make, and a different level for a contractor to make, for a non-compete to be enforceable. Whereas states where, like Massachusetts and Rhode Island, set different things for exempt or non-exempt employees. Sometimes they're enforceable, sometimes they're not, depending on the status of the employee, whether or not they're eligible to make overtime. So different states have different factors of enforceability. Generally, though, the major points when you're looking at a non-compete agreement are going to be how long the non-compete period lasts, the geographic scope of the non-compete, and what specifically is prohibited. For a majority of enforceable non-competes, you're looking at a shorter kind of temporal scope, a shorter time limit on those. Generally 6 months to 12 months is what you see majority of enforceable non-competes across the states. Other states can give you a little bit longer leeway on that. And then for geographic scope, What you look for generally is a geographic scope that's limited to what the employee was doing while they were working at the company, usually in the last 1 to 2 years of their career at the company, and then what markets the company is active in. So if it's a company that just works in North Carolina, for example, and you're working in a couple of different counties, they're looking for a geographic scope that would prohibit competition in those counties, not something that says, okay, you can't work in North Carolina, South Carolina, Virginia, something like that. So those are big factors that they look at.
Yeah,
The
that's
third,
great. I'm
yeah.
sorry, keep going, keep going.
Oh, yeah, no problem. So the third factor there is going to be the limitations of what the employee can do. So what courts have been looking at a lot more lately is how restricted are they in what they can do for a competitor. So if you're looking at somebody who is going from, developing code for one company, but now is going to work in janitorial at another company, a non-compete shouldn't prohibit that. So that's one thing that the courts have been focusing in on, as aside from the kind of geographic and temporal scope as well lately.
Okay, that's great, Andrew. And let me ask you this. I know you're in Massachusetts, but you're the national practice leader. I've heard many times in the past that Florida is kind of a right to work state in regarding the labor and unemployment. Is there any particular nuances? A lot of our listeners might be here in Florida that you know of that are in Florida and non-competes as they apply in the state of Florida that would maybe be worthwhile to discuss?
Yeah, so Florida is generally a state where you see a lot less regulation, a lot less control over things, at least on the employer side. And it also gives a little bit more freedom to employees. But non-competes are one section where Florida does have a law in place, which specifically allows for employers, in a general sense, to make a very restrictive non-compete. And so
Okay.
the difference in Florida is many states have what's called blue penciling, where the court can revise an agreement if they choose to a limited effect. In Florida, they have a required reformation, which means that the court will reduce that non-compete agreement to the highest enforceable level for the employer. So it's a very employer favorable law down in Florida.
Got it. Got it. Okay, that's really helpful. And Andrew, another thing that comes up whenever I was back in the day when I was doing my legal work and when I'm reading agreements for clients is many times they go hand in hand. You see non-compete and non-solicit. Can you talk a little bit about that to, the kind of the differences and the nuances between a non-compete and a non-solicit? Because I think those get confused a lot.
Of course, and they do. So a non-compete is specifically looking at prohibiting somebody from working for a competitor at all. And so it generally prohibits an employee from engaging in employment. A non-solicitation, they're usually divided into separate clauses: non-solicitation of employees and non-solicitation of customers. So non-solicitation of employees is your standard, it may be coined as a no poach agreement, a no direct solicitation. So you're looking at somebody who leaves your company and then comes back and tries to raid your employees. That's a non-solicitation of employees. And a non-solicitation of customers is generally limited to customers that the employee has knowledge of from working at your company. They cannot go to the next company and then come back and solicit all those companies for business at the new company. Can extend to independent contractors and relationships like that sometimes, but that's the main differences between those three.
Okay, great, great. And let me ask a little bit more. These are always questions I've had about these agreements. And like you mentioned before, you mentioned briefly, like exempt employees or different people. So a lot of times when I see it, when people are joining new companies, right, they're in let's set aside attorneys, right? Legal, because that's very different. That's a whole different conversation that they're not being enforceable. But when someone's coming into a company and they're negotiating the terms of their agreement, like, hey, salary, terms, all these different things, I see it's pretty typical in that contract for them to say, hey, we're going to have a non-compete and non-solicit. And I think that's very appropriate because the company's investing in this person, they're paying them, they're compensating them. So it's very rightly so that should be the case. Now, I've seen other situations where people are already at a company, right? And they were already employees, and I've seen it presented to them in a sense of, hey, listen, this is something new that we're trying to put in place, and you kind of either need to sign this or you need to leave. Can you talk a little bit about those two different situations? I think that will dovetail nicely into the FTC situation, whereas someone's coming in and negotiating these terms versus where it gets thrust upon you all of a sudden as a new condition of employment.
Of course. And those are generally the two, except for a separation, generally the two circumstances where you see these non-compete agreements arise. And so when you see a non-compete as part of your initial employment agreement coming into a company, if it's in compliance with state law, generally, that's the most enforceable point where you can engage into a non-compete with the employer. So if an employer puts that at the outset in exchange for hiring you, bringing you in, compensating you, that's going to be usually the most enforceable way to go about it as an employer. Sometimes you do see it come later, midstream of employment. And depending on the state, that may or may not be an enforceable agreement because they don't consider ongoing employment to be consideration for that. So sometimes you'll see it coined with a bonus, or some sort of significant raise or change in job title that allows for that significant raise or higher earning potential as part of that consideration for that. So midstream is a little bit less enforceable depending on the state. It may not be enforceable at all. So you have to make sure that you're in line with your state and local laws as well.
Okay, yeah. And I love this, for the non-lawyers out there, when you're talking about consideration, right? It's like saying, hey, listen, if you're gonna give me something, right? If you're gonna sign this agreement, I got to give you something for it as well, right? And saying that in that situation, then you might not be getting anything for being forced to sign it. And that's really any kind of agreement in the sense. It's kind of a quid pro quo. You got to be given something to get something. So Andrew, so let's move forward then. Let's talk about so this FTC. Maybe if you want, if you can give the background on it. I honestly didn't follow it that closely until it comes out. It makes all these big news. I'm getting all these different questions on it. So if you can talk to us a little bit about what the FTC has done. I don't believe it went into effect immediately. It might have already, be in effect, but talk about kind of what they did, if you can, why they did it, and now how is it going to affect existing or new agreements going forward to the best of your guess thus far, right? I'm sure it's still developing.
No, of course. And it's a timely conversation because it was slated to go into effect back in September, on September 4th, but it was delayed by court orders. It was basically a nationwide injunction out of Texas, which was appealable up until Monday of this week, and Friday of last week, the FTC noticed an appeal on that. So they're going to challenge that nationwide injunction, which basically means, it was not going to be enforceable, but now the FTC will be appealing up to a higher court. So we may be in a little bit more limbo and talking about this again in another 7 months or so too, which is the average time that it takes to get heard in the appellate courts out of Florida and Texas as well.
Okay.
But getting back to why it came to place originally, the Biden administration and President Biden issued an executive order, which directed the FTC, as well as other agencies in separate orders, to look into competitive and non-competitive acts under their purview nationwide as far as employees and management of employees were concerned. And out of that, about 2 years later, the FTC released what was this proposed rule on banning non-compete agreements. From there, the FTC refined it a little bit, took in some comments, and then, for better or worse, issued their final rule, which would have taken effect on September 4th, which may still take effect if these appeals are successful. So what the FTC rule basically did was it prohibited non-competes across all employment, as well as non-competes with independent contractors. And in doing so, it did it for every level of employee, broad slate across the board, with the exception of these non-competes entered into in M&A transactions, or the acquisition of a business, or the sale of a majority interest from an individual for that company. Aside from that, it allowed current non-competes with senior executives, which was very limited to almost purely C-suite executives, for those non-competes to stay in place post-ban, but not to enter into new ones as well. And the emphasis behind it, at least from the notes in the regulation, and from the pretext there, was that it is projected to increase wages by about $520 plus per year per worker in the United States. That was their evaluation of it. They looked at certain areas and certain industries that were issuing non-competes to employees that probably should not have been covered by these non-competes, but then issued a blanket ban across the board for everything, which is why you're seeing a little bit of issue in the courts accepting that level of what they call arbitrary and capricious rulemaking. Mm-hmm. So instead of taking kind of a piecemeal approach and saying, okay, in areas where intellectual property and assets exist that need to be protected, or C-suite level individuals and employees in general should be able to enter these non-competes, they just took this flat stance of non-competes are completely, unauthorized and illegal under the law. So that's why you kind of see this broad sweeping regulation that's being challenged a little bit, as opposed to something that was a little bit more dynamic, which is what people had requested, to say, we get that a line level staff member at McDonald's should not be covered by a non-compete, which was occurring in certain fast food industries, which is kind of what led to some of this regulation. But they took too wide sweeping of an approach, in many's opinion, and I think that's why we're seeing what we see here now.
Yeah. How do they come to this? How do they feel that wages would go up because of it? Kind of what's, if you could tie that together, what are they saying that because people will be able to move jobs more freely and negotiate better wages?
That's the major basic for it, is basically giving employees back the threat of being able to quit and go to your competitor, and negotiate back and forth amongst companies. The other piece of that ties into that is from the National Labor Relations Board, which, in their opinion as well, in a general counsel opinion from them, found that under their purview, under the National Labor Relations Act, that non-compete should be unlawful with all non-managerial, non-supervisory staff in general. So they have their own perspective on it as well. And one of their reasonings, their stated reasoning behind it, is that now employees can basically threaten to quit and threaten to go to a competitor for better wages and better working conditions. So that's where they see that kind of press to compensate higher.
Yeah.
Whether or not that plays out that way, yet to be seen.
Yeah, I mean, I've always seen this as the issue of the non-compete, like you say, where they try to carve out pursuant to an M&A transaction. And so that's very clear. I love that you pointed that out. Absolutely, right? You have talked about consideration, right? You've paid considerable, amounts of money so that they can't go and compete. And the person that signed that agreement had the ability to negotiate the terms of that agreement, right? When you're selling your business, you have the option. I don't have to sell it to you if I don't want to. And most, I think, good attorneys and business owners will tell you, right? There's the old saying, "Hey, if you want to dictate the price, I'll dictate the terms," because the terms is almost many times more important than the actual price. But then going into, like you're saying, for people that are not, they didn't have the ability to negotiate their terms, right? Coming in, and they're non, even maybe to a certain degree, managerial. If the employer did not come in and make this a part of them joining, because before you've joined, right, when you're free to open up and sign whatever come on board, they can present something to you. You don't want to sign it, fine, don't come over, right? That's pretty simple. So that makes a lot of sense to me. And I mean, how have you seen in your practice, like the employers? I mean, would you agree, would you not, that could be kind of overreaching when they come to you and say, we want to make everybody sign one versus just the decision makers? I mean, what's typically kind of, the advice and the scope, to go towards reasonableness that you give to your employers when they're trying to think about having employees sign non-competes?
Yeah, and I would say, outside of, a tech startup company or something that's highly involved across the board in all employees that you have. If you have a 10 employee unit starting all founders in a company developing a product, that might be the one circumstance where everybody has a non-compete there, because everybody is involved in the foundation of the company, usually has either stock or equity interest in the company moving forward, and is
Mm-hmm.
deeply involved in the IP and the marketing of the initial product. Outside of that space, I generally wouldn't recommend any employer have a blanket non-compete policy. It's very difficult to justify that, in the larger scope of things outside of a different protected environment. So when we're looking at things, maybe in the music industry, maybe in tech, or you're looking at something that's more confined to a smaller unit of people that are involved in the direct development of the company's assets. But as you get larger, or if you're looking at kind of a wider industry, you see it a lot in salons, actually, in a lot of cases where they have non-competes with hairstylists and hairdressers, and things of that nature, where they're generally not going to be enforceable. But there's some industries that have these blanket non-competes just as a matter of course, because it's always been done in those smaller industries, where you're not going to find a lot of enforceable non-competes. And the same thing goes for a larger company, is you don't want to blanket non-compete your workers that don't have, you wouldn't be able to back that up in court. If you're looking at specifically protectable interests, you have to be able to think that I'm going to have to go to a court someday and be able to justify why this employee has a non-compete agreement if we're trying to enforce it. Um, and you're not going to have a lot of ammo for that if you're just a blanket non-compete for every worker that comes in and you're running, for example, a daycare or a restaurant or things like that, and every employee has one of these agreements in place.
Yeah, that's awesome. That's great, Andrew. I love that term, protectable interest. And can you give us some examples there? Because I think a lot of people, a lot of employers try to think like, hey, we do something unique, we have something cool, and they might have something a little different, a little innovative, but there's nothing really special about it, right? And really, when they're hiring people, And when they're trying to compete in the market, they're just trying to get it sold, and they're trying to get it sold to as many people as possible. That's where they try to say, well, we're kind of special, so we should restrain people that come work for us. But can you give us some examples of some protectable interests that you think are very valid, like you mentioned there, IP maybe to start, and others that are not, so that if anybody listening to this is thinking about whether in creating and having employees sign new non-competes or thinking about their existing non-competes, what are some valid and really not valid protectable interests?
No, of course. And so when you're looking at intellectual property, it's, the fundamental product of your business or the product development. And what you look at there is this information available publicly? If so, you're going to have less of a protected interest. If it's not publicly available information or highly protected information of the company. So when you're looking at a new product that's in development or a product that your company has developed that no one else in the industry understands how to make or can make at this point, you have more of a protectable interest. It also extends out to sometimes when you're looking at a sales organization, for example. If it's a sales organization where you're not generally in the public going door to door soliciting sales like that, but you may have a couple of niche clients that aren't publicly known, and it's more of a kind of a secretive industry about how those relationships go, how projects are bid, how you structure your marketing and assets and your rate range versus the industry. If it's a very competitive market like that, and a lot of that information is not available publicly, and another company has no access to that and wouldn't have any idea of how you're doing that, and you're in direct competition, then you're looking into some of these protectable interests. Is the big piece of it is you want to make sure it's not something that's not publicly known generally. And if it's something that the company has developed independently and you have knowledge of that would benefit another company from having that information, those are kind of the gems of the industry. If you have those items, you're going to have a lot more strength when you're arguing that. Not saying that has to exist in every scenario, but those can really go far in enforcing these non-competes, and they really support an argument that we have some sort of protectable interest that we need to protect from this individual going to a direct competitor.
Got it. Got it. That's really great. So let me ask about a couple specific industries, and I'll talk about my industry. I have a lot of doctor clients and the like, and I want to take this from the point of, I think it's pretty clear, right? If someone comes in and buys your business, you're getting a whole lump sum of money. Both your non-compete and your non-solicits, should apply. But let's say they're, once again, in the medical versus the financial services or banking industry, right? So you're tasked, more so in the financial services, maybe not in the medical, but you have it some as well. You're tasked to kind of grow a practice, right? So Dr. Andrews out there, he got hired straight out of med school, but he's developed a practice for ABC Medical Clinic, right? They know him. They really like the services he provides, and he is under that kind of non-compete, non-solicit, just like a financial advisor. I think it's much more prevalent in financial advisors, especially with these large banks, right? That they're warned, they're given all the tools to go out and get clients, but it's solely their effort. They're getting the clients, and then the banks and the financial institutions want to say that they're their clients. So someone like a professional in those two scenarios where they have built these practices over these years and they're starting to feel, hey, this might not be the best fit for me anymore. I want to go do something different. What are some of the things, they're going to go back and review their non-compete or non-solicit, so what are some of the things they should look for there? And then they decide that they do want to make a move, kind of what can they expect? Like what's reasonable and what's not unreasonable in these situations where they feel justified in doing this because the clients only know them.
Yeah, and so it's interesting that you pick the medical field, because the medical field is one of our, the most nuanced and specific industries as far as regulation of non-competes. And so there's a couple of different areas that are generally pieced together in state law. And lawyers are generally exempt because they set their own regulations through their own ethical guidelines. And so they exempt themselves from non-competes pretty much every state that they practice in, get the benefit of that. Outside of that, the medical profession is regulated state by state basis, and generally a doctor, for example, can have a non-compete in certain states. Generally, in the South, you see it a lot more. As you move up to the Northeast, there are a lot of statutes that are written in place that say that, anybody that's running a medical practice or a doctor or several different levels within the medical profession of credentials also cannot be covered by non-compete agreements. So the first thing you need to do is look at where you're practicing and what the state law that covers you are. And then you look towards what's an enforceable non-compete. And generally, that's where I come into play. And somebody comes to me and says, Andrew, can you take a look at my non-compete agreement and these other restrictive covenants is what they call them, that cover your non-solicitation, your non-disparagement, confidentiality, things like that. And let me know what's enforceable here and what I can do. Can I set up a new business and then clients have to come to me organically, or can I take my business with me because this is completely unenforceable? So it's an evaluation that has to take, a couple different factors in, and is one of them is, does the state have a statute that covers this? And does it say that you can have a non-compete, but for medical providers there, for example, there's some very niche rulings out there that say, okay, in certain states, if you're a medical provider in one county and you move to a different county that's underserved, then the non-compete is unenforceable. So there's things built in for the good of the community generally in the medical profession as far as non-competes go in certain states that you have to keep an eye out for too. So it's kind of, you look at it a case-by-case basis and say, locality, state law, what's the full scope of these restrictive covenants? Can I start a new practice? Can I move to an established practice but not bring my clients? Can I bring my clients with me but I have to be a different county? It really depends on where you are and what you're doing.
Okay. And how about the financial services, right? Because a lot of those big firms, like what have you, I don't know if you've worked on those, that's a big topic in our industry. All these people are trying to move, and then there's a protocol amongst firms to say what information can and can't be shared. What do you see there for these people that in essence basically built their book of businesses, and then they're told, probably, I'm not disagreeing with the employer to say that, hey, listen, we paid you, we did all this stuff for you to keep it there, but now they want to move. What are some of the things that they need to think about that might, you mentioned something very specific to doctors. That's really interesting. But anything on the financial services that they might be aware of?
Yeah, a little more difficult on that side of it. And it depends on, well, it depends on the future and how the FDIC looks at certain things, depending on what institutions you're working at. So there might be different coverage coming down the line, depending on the specific employer, the specific bank or firm that you're working at. If you're looking at more the private equity side of it, or the non-covered banking side of it, then it's going to be a lot more difficult because it's a little bit less regulated. So the financial advisor, even at those covered institutions currently, is not going to have an easier path than the medical professional would, or and not exempt employee would, for example. So it's going to be a lot more difficult because you're making a lot more money for the company. You're usually being compensated a lot better. So the court will take that into effect and say, okay, I feel a lot less bad for the guy, even if you pour your heart and soul into this work, which a lot of people do, to build these books of business. They're going to say, okay, well, we feel like he was fairly compensated for what he was doing or what she was doing, and you're going to see a lot less ability to get out of those agreements from the financial services side of it than you will from example for the medical side of it, or anywhere outside of that. So it really depends, again, like I said, on state locality or where you're moving to. If you're moving out to California, for example, that's the best state to be an employee, as far as regulation and coverage on employment law goes. So it's a little bit different of analysis, aside from moving across the street down in New York.
Yeah, that's great. I really appreciate that answer. So Andrew, so let's say that the FTC is challenging. The FTC wants to get this rule in place, start to be enforced right away. Let's jump into our time machine here. At the time, whenever the FTC, let's assume, that's all we can do, arguendo for this situation, that the rule as proposed does eventually go into enactment, right? And it's applied across the country. If that were to happen and somebody is sitting in a situation where they are subject to a non-compete agreement, okay, what's the analysis they should go through? I mean, I think a lot of people had reached out to me and they're like, hey, I saw this happen. My non-compete doesn't apply anymore. Hooray, right? I mean, that's not so, right? What's kind of the analysis and the steps they should go through initially to think like, hey, whether does this actually apply to me, or am I one of these kind of exempted, more C-suite executive decision makers where my non-compete doesn't get affected by this?
Right. So if it does come into effect, I mean, the first thing to look at is salary threshold. That's the easiest factor to look at. The base of that is 151,000 annually. It matches kind of the increase in what we call the executive, or highly compensated executive exemption under FSA. So it's 151,000 basically, is our salary threshold that we look at first. You're below that, you're not going to be considered exempt from this. So that's the first piece of it. The second piece of it to look at is, am I truly a C-suite executive that has the authority to make wide sweeping decisions for the company? So they specifically kind of filter out some of these positions. So if you're looking at, for example, the CEO generally has that authority to make those decisions, direct the course of the company, bind the company to certain contracts and agreements that on a company-wide basis. That carries down to level, usually your CFO has a strong amount of authority as well. But when you start getting to some of our newer C-suite positions and roles, not even that new, but if you look at like your chief marketing officer, for example, is not going to have the same company-wide authority as your CFO or your CEO would, or your COO would.
Mm-hmm.
So you look at roles like chief marketing officer, your CHRO sometimes, or even you're looking at some of your DEI officers that are now chief DEI officers in companies. If they don't have that kind of wide sweeping ability to make those directions for the company, as opposed to make recommendations to other members of the C-suite, like the COO, the CEO, then you may not fall into that exemption. Your non-compete could be invalid. And the onus is on the employer to evaluate that when the regulation comes into effect. And actually, they're required to give notice to all affected individuals that the non-compete that they've entered into is no longer in effect if the rule does come into play.
Wow. Okay. So really, really interesting. So that kind of goes to what I think is reasonableness, right? If you say if you're not, really well compensated and you have no decision-making ability, this shouldn't apply to you. Your employer should not be able to restrict you from going anywhere because there's nothing. I'm not gonna say there's nothing special about you, but that the position and the role you hold there, you should be allowed to move as you need be, and prove yourself if they're not going to kind of step up and pay you more or giving you the decision-making ability. And I think that's really interesting. Whether I wonder how many employers will come down and send that notice when this comes down. So Andrew, let me ask you one more thing, to go back to kind of this nuance between the non-compete and the non-solicits. So, and correct me if I'm wrong. Let's say, once this does go into enforcement, the non-compete, and let's say you're in a situation where the non-compete is not enforceable anymore, it would seem, I would guess, that as long as it's drafted correctly, that the non-solicit would continue to be enforceable. So can you speak a little bit to that about maybe like if that's somebody, whether because of the rule becoming enacted or in the future they want to leave and they want to navigate their non-compete, that to kind of explain, but now you also have the non-solicit issue, right? So depending, these different clients, some people will say, well, if they call me, I can't stop it. I mean, what's kind of like some of the caveats and things to be aware of when you're negotiating a non-solicit, if it's found that your non-compete is no longer enforceable.
No, of course. And so one of the big pieces that has been coming to play now with the original expectations the rule would come into effect back in September, and you've seen a little bit of a shift, at least in the M&A side of the world, when you're entering into these acquisitions of companies, bringing on these new employees, entering into agreements with them is crafting the non-solicitations in a way that protects you in the event that the non-compete rule does come into effect. So you're seeing a little bit less of a focus on non-competes, and more of a focus on crafting these nicely crafted non-solicitation agreements that have to walk a fine line. So you're correct in saying that the non-compete is no longer in effect. The non-solicitation does continue to stay in effect as long as it's drafted well. And so the FTC has not explicitly said what would make it enforceable, what wouldn't make it enforceable, but they do speak to kind of an overbroad prohibition of being able to work in the industry. So what that threshold would be would have to be filtered out either in agency rulemaking in the future or in the courts, and challenges to that. But you're looking at something that protects the interests of the company. It doesn't go so broad as to saying the individual cannot work for a new company, because of these items. And they talk about that in the concept of a confidentiality clause as well, because when you look at confidentiality clauses, depending on the information the company is trying to restrict from disclosure, it can go beyond what is necessary and travel into a world where the employee can't say anything. I've seen some very poorly drafted confidentiality clauses, whether or not they come from a chat GBT or some other system or somebody's pulling it off the internet, where they're prohibiting the discussion of any company information whatsoever, which is not an enforceable non-compete, but also would likely violate the FTC's regulation on competition because it would prohibit that individual from bringing any information whatsoever, even not confidential information, to a new employer. So you have to be careful with some of these policies and how they're drafted. The other side of it is, while they haven't expanded too much on what would truly be an enforceable version of it, the FTC has said that what's called a garden leave period would not be considered a non-compete. And for those who don't know what a garden leave period is, it's basically when an employee is still an employee of the company, but not doing anything for the company, but retaining their salary and all their standard benefits as it were. It's an alternative to a severance program or a separation agreement. It's usually tied into those things. But basically, the employee stays on the payroll, just doesn't have any job duties. Some great examples of that, I think, in the Silicon Valley series, if anybody watched
I
HBO.
want to. My wife liked it. I see it popping up. I want to watch that.
There's a great scene where one of the characters, Nelson, is basically put on a garden leave program there, and they say, we don't fire anybody at our company, but they all hang out on the roof, and they just work out the rest of their contracts there, doing nothing and just collecting a salary. So that's kind of what you're looking at with garden leave, where the FTC is like, well, that's okay, because they're still technically an employee of the company and being paid. You're just not asking them to do anything or giving them any authority.
Yeah.
So there's a couple of different things that you can put into agreements in place now, just in case there's concerns down the road about enforceability.
Yeah, and one I said final thing before I have another question, because I'm really enjoying this conversation. So let's say someone's a little more seasoned, right, and they're coming to the company, and I've had situations where I've talked about people to join my company or for us to do certain work together, that when you're entering into this new company and you're asked to sign the non-compete, or more importantly, say the non-solicit, to say, hey, listen, here's a list of people that I already have relationships with, right, that are already kind of my clients, whatever they might be. I would think it'd be a good strategy when they're coming forward to say, hey, listen, these are a list of individuals that are exempt from these non-solicit provisions. What have you seen in regarding into that? Do you see employers, are they amenable to that, or do they say, no, this is a blanket prohibition, where you're coming in, you're saying, I'm not just out of school, I'm 10 years into this, I have relationships, I'm not going to, leave employment from this organization and not be able to call my best friend next door.
Yeah, and so that actually has been incorporated a lot. And when you're looking at your rainmakers, especially those people that you're recruiting to come over to your company that you want because they've developed this book and these relationships, you do see a lot of exempted relationships from these agreements. So whether it's bringing, this is my client list, these are the clients that I've had for 10 years, they developed my book, I will bring them with me, but when I leave, I'm taking them with me. Other clients post-generation will be a mixture between the company or my client, depending on how they're generated. So you see a lot of different types of agreements with these individuals that come in, and sometimes it's based on how clients are generated. If they're bringing a book with them that's separate out, and then new generated clients are going to be company property, there's a mixture of how it's just treated depending on the individual and how they negotiate. It's the similar aspect of if somebody's coming to a company with a list of patents or inventions and they want that to be excluded from a work for hire agreement as well. So you do have some negotiation ground, especially if you're in that situation, because the company obviously wants you and wants your book and your clients to come over. So we have seen that a pretty common practice when you're looking at some of these individuals coming over that have a little bit more seniority.
Wonderful, wonderful, Andrew. So let me ask my big blanket, I don't know if it would be lawyerly or business negotiator question. So I've really enjoyed this conversation. We've hit on a lot of these topics, but is there anything that you're kind of seeing, that you're thinking about, that I haven't really asked you, that you think might be useful for anybody out there that's navigating existing non-compete agreements, or is trying to prepare for whatever this potential rule, this rule potentially going into effect in the near future?
No, of course. I think this is just a kind of an amalgam of what we covered. I mean, the major points are to just be prepared in any circumstance, because you may not always be in a state where you can revise your agreement midstream to enter a non-compete later, or change your restrictive covenants later. So the big focus now is, just in case, 8 months from now, a year from now, the rule comes into place, you want to make sure that you have enforceable agreements in the event that your non-compete is no longer valid. You want to have these nicely tailored, protected non-solicitation clauses in there and refine your confidentiality and non-disparagement clauses so that they don't go to an overbroad level and are found to be non-competes as well. So you want to focus on the other areas of agreement that typically don't get as much action or attention as the non-compete does because it's such a big draw for people. So my big recommendation, a lot of deals that we work on, is that we want to focus on those other restrictive covenants and make sure that they're there to protect our interests in the event that the rule does come into play.
Yeah, I love it. The terms, right? You name the price, I name the terms. The devil is so much in the details. And when someone comes out and this blanket information like the FTC comes down and says they're not, enforceable. So, but that's fine. But there's so much more that goes into than just that issue, and well crafted and thought through. Good lawyers, good clients, and being reasonable, right? You can really get yourself to where you need to be, and potentially even in a better situation, right? Because this is now going to force you to think about situations and aspects of these agreements that you haven't in the past.
No, exactly. And that's one of the big things is it's given us the ability to talk to employers to say that we want to dig in a little bit more on the minutia of these agreements to make sure that everything is fine tuned, and employers have a little bit more backing into it now to say, okay, I want to make sure that happens because these regulations could come down at any time.
Awesome. Awesome. So Andrew, listen, thank you so much for your time. I think I found this very helpful. We're going to have all your information in the show notes, your firm, and anything if anybody wants to follow up with you or anybody else in your firm. I've learned a lot from this. So I think hopefully a lot of those out there watching this will find this very truly valuable.
Well, I hope so. It's been a really enjoyable experience on my end. Thank you so much, Stephen.